Section 13D of the Securities Exchange Act of 1934 requires any person or group that has acquired ownership of more than 5% of a corporation's stock to file a disclosure statement with the Securities and Exchange Commission. In CSX Corporation versus Children's Investment Fund Management, LLP, the court considered whether two or more parties must act with the specific purpose of acquiring corporate stock to constitute a group under Section 13D. In 2006, Children's Fund Management and 3G Capital Partners, two investment funds, entered into equity swap agreements. The two funds sought to change the corporate policy of CSX Corporation to maximize the corporation's value. The funds acquired voting stock in the corporation, as well as long positions in cash-settled total return equity swaps that referenced the corporation's stock. Several banks held the short positions in the equity swaps and bought CSX shares as a hedge against the swaps. By April 2007, the funds collectively owned more than 5% of the corporation's stock. However, the funds didn't file a disclosure pursuant to Section 13D of the Securities Act at that time. Thereafter, the funds engaged in a proxy contest and attempted to vote in new directors to the corporation's board. CSX filed an injunctive action seeking to enjoin the funds from exercising their corporate voting rights. Specifically, the corporation asserted that the funds constituted a group under Section 13D and thus violated that section by failing to file a disclosure statement. The district court agreed and permanently enjoined the funds from future violations of Section 13D. The funds appealed to the Second Circuit, arguing that the district court erred by granting an injunction without finding that the funds constituted a group for the specific purpose of acquiring the corporation's stock, as required by Section 13D.